Okay, great. Thanks. Thanks, Taviso. Yeah. Taviso just said, happy to come to the firm. Having connectivity issues. So yeah, this is my point. Okay, so we're recording. So okay. So today we are going to be talking about sort of procedure for obtaining a patent. And we're going to be talking about the difference between an applicant and an inventor, the different kinds of patent applications that there are, and the actual procedure behind it, which is a little bit boring, but it does get the job done. Grant, duration, effect, and then of course patents. It's very easy to have mistakes in them, or because they're these big technical documents, you often need to correct them, you often need to amend them. So we need to talk about the difference between a correction and an amendment, and how you can correct and amend patent applications at the different stages of their life, and the different requirements that are required from them. So that's all tricky. And then opposition, we don't have opposition, but you can oppose an application for an amendment. So that's quite interesting as well. So we're going to talk about that as well. So let's start at the beginning, which is applicant and inventor. Now, I'm sure you guys have all got Dean and Dyer, and we'll be working today from page 252, which is procedure for obtaining a patent. Okay. So the first thing I want to talk about is an inventor and the difference between an inventor and an applicant. So you can think about it the same way as if you think of a house as the patent, and then the builder would be the inventor. He's the guy who kind of created it, and the applicant goes on to be the proprietor, is the owner. So sometimes a builder builds his own house and owns it. So he's both the inventor and the applicant / proprietor. But mostly builders build houses and then sell them on, or build houses on behalf of other people. And then that other person pays the builder and becomes the applicant / proprietor. And that's exactly how it is with patents, right? So the inventor is the crazy guy in the lab coat who kind of adds things together and gets it done. But more often than not, he's like a scientist. And he's either employed by a big company like Pfizer or, Aspen, or a university or an Anglo-American. And his job is actually to solve problems, right? And as you know, with patents, it's all problem and solution. So, if you work for Anglo and you've got a problem, they want to improve how much gold they leach out of iron ore, they come to the scientists and they say, currently we're getting 6 grams per ton. We need to get 8 grams per ton. That's the problem. Solve it. And so he goes away and he plays with the chemistry, and then he changes something, and then he's able to get 8 grams per ton of gold out of the rock. And those changes then form the subject of the patent application. So he's the inventor because he thought about those changes. He said, do this, do that. Let me try sulfuric acid instead of hydrochloric acid or whatever. And that resulted in the technical advantage of now getting 8 grams per ton, right? But he's always been paid to do that by Anglo-American, by his employer. So Anglo-American will be the ones who apply for the patent and eventually own the patent. He's always going to be listed as the inventor, but the rights of to the invention pass to Anglo-American by virtue of his contract of employment. And very often we'll need to make that clear by just asking the inventor to sign a deed of assignment, whereby the rights in the invention, the right to apply for patent, etc., passes to a third party. So that's the most common scenario. But it also happens that guys invent something in their garage, and then they get some investors on board, and then the investors buy it from the inventor. The inventor signs the deed of assignment so that it goes to the investors, and then they're the ones who own it going forward. And then the inventor is retained either maybe he has a small share in the holding company, or he earns a salary as a kind of consultant or something like that. So and it's important to understand that an inventor is the guy who, he's the guy who thought of the inventive concept. So if we go back to my Anglo example, he's the scientist, he's sitting there and he thinks, now, what if I change sulfuric acid for hydrochloric acid? He doesn't actually have to go and do that in the lab benches, right? He can say to his sidekick, go do a leaching experiment, but instead of using sulfuric acid, use hydrochloric acid. Now, the guy who goes and does that experiment, he's just the hands that do the work. He's not the inventor. He didn't have the idea to solve that. He's just the one who makes it happen. So the inventor is the guy who suggested change sulfuric for hydrochloric, not necessarily the guy who did the experiments. So, that's kind of how it works. So it's important to understand, and there's a good case law on that. It's Gallison Manufacturing, and he says there's not a lot of case law in South Africa about this, but the task of the court is to identify the inventive concept of the patent application and identify who devised it. So yeah, so that's determining of inventorship. So an application for a patent can be made by the inventor, any person who has acquired the right to apply from the inventor, or both the inventor and such person, okay? And if the applicant for a patent is not the inventor, he must prove his entitlement to apply. So he'll need to produce a deed of assignment or something like that. But the inventor always needs to be listed. And if you miss out an inventor, it's quite a bad mistake. So if you get a patent and you don't acknowledge somebody who was an actual inventor, then you've got a problem. And that could, in fact, be a ground for revocation. So you have to be very careful. The establishment of who an inventor is a question of fact, and you really need to apply your mind to it, because if you get it wrong, it can have profound implications for the validity of the patent going forward. So as a patent attorney, as a practitioner, you really need to get that right, and that's at the ground floor, okay? As a patent attorney, you can figure out quite quickly who the inventor is because they know what they're talking about. And you say to them, oh, okay, so you use an acid there. Can you use an acetic acid? And the inventor will go, no. You need to do this because of that, and that one's not strong enough, or that one's too strong. So you know immediately, this is a guy who knows the technology. This is the guy who solved the problem. When they sit there with a mouthful of teeth and go, don't know, leave that with me, then he's trying to be an inventor, but he's not. So that it's just something to bear in mind. Okay, so now you've got your inventor, and he's given you the whole spiel. He's told you what the problem is, and he's told you how to what the solution is. So now you, as a patent attorney, take all of that information away, and you draft a patent specification. And a patent specification is they're all built along the same precedent, right? And I think the presentation that I asked you guys to watch deals with what a patent application looks like, and they always tell the same story. It starts off with an introduction. It then starts off with what's already known on the technology at the moment, the technology platform and how it works, etc., etc. And then it'll go into an identification of the problem, in the sense that, for example, using these techniques, we can only get 6 grams of gold per ton out of the rock, and a need exists to increase the yield of gold from rock. And then it goes on to say, well, the inventors have solved this problem by replacing sulfuric acid with hydrochloric acid. So that's a solution to the problem. So you've identified the problem, and then you go on to explain the solution. And then you go on to say, well, it can be used at this concentration and at this temperature and at this pressure. And yes, we've said hydrochloric acid, but these other acids will also work. So then you go into all the combinations and permutations of the invention, because it's not just that one single inventive point. As a patent attorney, you have to take that point and expand it into an inventive sphere, which covers all different embodiments and examples, etc., etc. So once you've done that, Then you go into the examples, and you can say, I did this example with hydrochloric acid. I did this example with acetic acid. This one didn't work. This one did work, etc., etc. And then you end with claims. And claims, of course, define the monopoly that you're trying to get for the invention. And, so that they are probably the most important part of the specification. The description, the problem, solution, the examples, all the different embodiments, they support the claims. And the claims are what you look at when you're defining or you're determining what exactly the monopoly is. So that's how you build a patent specification. So you build the specification, you send it to client, and you say, what do you think? And client comes back and says, no, I want you to change this, I want you to change that. There's a little bit of back and forth, and then voila, you now have your patent application and you're ready to rock and roll. So this is where we now come in. And this is where I want to share my screen, and hopefully I can get that right. So share, and Sally, can you let me know, can you see that? Okay. Sally, you're the only one left, so can you see I'm sharing my screen? I've got a Word document up. Okay.
Yeah, I can see it.
Great. And can you see my little arrow moving around there? Yeah.
Okay. Yes, around the globe.
Yes. Yeah. Awesome. Okay. So, right. So this is what you're talking about. So there's a light bulb moment, right? The inventor says, oh, okay, to solve this problem, I need to replace sulfuric acid with hydrochloric acid. He has an idea. He then goes to consult his patent attorney, and they draft and finalize the patent specification. And there it is. Okay. Somebody's waiting in the lobby. DBS's back. Okay. Sally, can you still see my screen? That Word document. Okay. Sally, can you still see the screen, or are you back to the Teams?
I can see the screen.
Okay, great, thanks. Tivisa, you should be able to see the screen as well. Okay, so what we've done is we've now prepared our specification, which is the patent application text. Then what you do is you file a South African provisional application to establish a priority date in terms of the Paris Convention. So remember, that's what we were talking about 2 years ago. So say, for example, we filed it on the 1st of March, 2021, okay? And that establishes the priority date by which novelty and inventive step of the claimed invention are judged, all right? So after this date, before this date, anything which is published can be used to say, no, the invention is not novel because it's described in this previous document. This document is dated, 1st of January, 2021. It was in the public domain before you filed your before you established your priority date. So it is valid prior art against your application for the purposes of novelty. So it's said to anticipate your invention. So, but after the 1st of March, on or before the 1st of March, you can discount anything and everything which is published. So it's very important that you get an early priority date and that you maintain it. Okay, cool. So we filed our patent application. Yay. We've got a priority date. Yay. Okay, now what? So now there's a 12-month priority period in terms of the Paris Convention. Okay, from there, so on or before the 1st of March, 2022, you then have to choose one of these 3 options, or the application just dies, okay? Just withers on the vine. So what do you do in this 12-month period? Well, you can, often you continue working on the problem. If you're a scientist, you get stuck into the lab, you do more examples, you do more embodiments, you can say this works, that works better, etc., etc. You still amass a lot of technical information relating to the invention. And so at your one year anniversary, when you revisit this draft specification, the provisional specification, you can include more information. You can update it with the latest information to create a complete specification as opposed to a provisional specification. Provisional spec, but after 12 months, you then have to do a complete spec, okay? And it's your complete specification which then supports the patent going forward. Now, at the 12-month priority period, you have 4 choices. You could say what? Option 1. Okay, option 1 is down here. Abandon and withdraw the application, leaving no rights outstanding. Okay, it's like the application never existed, leaving the applicants free to refile again, either now, directly now, or at some point in the future. And in so doing, they would reset the clock, right? So now your priority date is no longer 1st of March 2021. It's the date that you refile it, which would be the 2nd or the 3rd of March 2022. And you better hope that there's been no intervening public disclosures of the technology, because then you have given up rights to your first priority date, you've established the second one, and you hope that nobody has come onto the platform in that meantime, because then they would anticipate you, right? So you can do that, provided, of course, that there's been no intervening filing by a third party, which could anticipate any such refiling. By abandoning the application, the applicant abandons the rights to their initial priority date. Okay, so that's the first one. You can just say, you know what, this is not going anywhere. I'm not interested in taking it forward, putting any money in it. I'm just abandoning it. I'm leaving no rights outstanding. And it's like I never filed the first one. And maybe I'll come back to it. Maybe that's just the end of it. Okay, that's option 1. Option 2, yeah, to be so. Yeah, hi.
In terms of option 1, if we abandon that invention, does it now become a state of the art or prior art?
No. Awesome question, to be so. No, it doesn't, because your first 12 months and 6 months into whatever option you choose, it remains secret. It's only after 18 months that the application publishes and becomes public domain. So if you choose option 1, it's like it's never been made available to the public. So it's still an invention, provided that somebody else hasn't thought of it independently. They certainly wouldn't have had access to your application. So it remains secret. It's not open to public inspection for the first 18 months of its life. Okay.
Thank you, Prof.
Okay, so that's option 1. You can just take your ball and go home and say, I'm not playing anymore. But your invention will never have been made available to the public. Option 2, you can say, you know what? I'm just going to file in South Africa. So I'm going to prepare my complete specification. I'm going to file it on or before the 1st of March 2022. I'm going to claim priority from the priority of the provisional application, 1st of March 2021, and it'll just go to grant in South Africa, and I'm good. And then I'll just have a South African patent, okay? And that's what a lot of people do. They just file in South Africa, and then they take option 2 to file only a South African complete application, which will proceed to grant in South Africa in due course. This is every lecture I tell you that there are dog legs in South African law, little quirks, and this is one of them. If you do that, it doesn't actually become public domain at 18 months. It in fact only becomes public domain once it's been granted, which is a year after this. So this way it remains secret a little bit longer. Why? I don't know. It's just like one of those weird things in South African law that if you take option 2, this application does not become open to public inspection at 18 months like all the other applications, and instead can only be seen by the public when it is granted. Okay, so that's your South African one. Okay. Option 3 is you say, you know what, this invention is really cool. It's got legs. There are people in Europe, there are people in America who are interested in it. I'm going to file in those countries. Okay. Not only I can do option 2 in conjunction with option 3, which is to say, when I file in South Africa, I'm also going to file in the US, Europe, Australia, or whatever other countries I want. Okay. So that's option 3. Option 3 can be pursued in combination with option 2 above and involves filing individual or convention applications in other Paris Convention countries, timeously of the 12-month priority deadline. So you just go straight from South Africa provisional within 12 months, you file straight in the US, straight in Europe, Australia, and it's all got to be done within 12 months. This used to be the way that it was really done up until about 1999 in South Africa, which I know seems a long time ago for you guys, but seems like only yesterday for guys like me. But anyway, that was a very popular option. You just used the Paris Convention, you used your 12-month convention period, and then you filed in America. It resulted in like a huge amount of work here because you had to prepare all these applications and get them in the post and fax them across the world and say, you've got to file it on and before 1st March 2022. And, you know, that was a nightmare. So it's still used, but by far, the most popular option is option 4, which is what's called the filing of a patent cooperation treaty. So, and you can see it starts its own timeline down here called C over. So option 4 is the most popular option and involves filing a single patent cooperation treaty application which preserves the rights of the applicant in all member states of the PCT, currently about 150 countries around the world. Okay, and details of which are set out on the next page. So what happens is you'll have filed your provisional, you'll just have one application, and then at this time you'll say, you know what, this application is really looking good. I think I might actually want to file it in the US. I might want to file it in Europe, etc., etc. So what I'm going to do is I'm going to file a PCT application, because what a PCT application does is that you file. So this is where we're coming in from that first page, right? You file a PCT application on or before the 12-month anniversary of the priority date. And then you have what's called an international phase of the PCT application, which it's just a single application pending, but it preserves your rights in all of the member states of the PCT. So, you know, there's 150 countries which are waiting to see, are you going to enter your application here? And during that 18-month period, which is in addition to the 12-month Paris Convention, because that would have been down here, right? You then, what they will do is they will publish it at 18 months from the priority date, publication with an international search report. So these guys will, so the PCT are actually, it's part of WIPO, part of the World Intellectual Property Organization. So it's this international treaty, and they've got guys in Geneva who will do all of this with you. You actually file your application and get sent to the WIPO PCT offices in Geneva. And what they'll do is they'll actually search it. So they have like a huge team that says, oh, this is about gold extraction, and let's send it to the gold extraction team. Next one, oh, this is about golf balls. Let's send it to the golf ball team. So you've got thousands of people, all have these little areas of subjects of specialization, and the application goes to them, and they said, search it. Tell me if this is novel. Tell me if this is inventive, compared to the prior art that existed on or before the priority date of the application. And so what happens is you get this international search report 6 months from the date on which you filed the PCT application, which is in fact 18 months from the priority date. And then they've also got teams, they work in conjunction with patent offices around the world. And what will happen is you will actually get an international preliminary report on patentability. So they will tell you whether they think it's novel, they'll tell you whether they think it's inventive, etc., etc. And you'll get this IPRP report, which then sits on the back of your patent application, and wherever it goes, this report goes with it. So it's quite important to get a good report, because you are, it'll save you trouble down the line if the international authorities think that your idea is patentable. Most patent officers will listen to that. And certainly if they contracted, for example, the European Patent Office to give that preliminary report, and then you file in Europe, they'll say, what does the preliminary report say? Patentable? Boom, you're in, no problem. So it's important that you actually do get a good preliminary report, and the opportunity does exist to write to the international authority to argue your case or to make some changes to try and get a good IPRP. So that's quite important. Okay. So now you filed your PCT, you have an 18-month international phase. So that at this point here, it would be 30 months, 18 months international phase plus 12 months priority. So now you're sitting at 30 months. So that's 2.5 years after you filed your first provisional application in South Africa. That has given you a lot of time to think about whether it works in practice, to look at the search report, to look at the preliminary report on patentability, and decide, you know what, I'm going to go for this. This looks good. And it's at that point that you then have to enter what's called the national phase of the PCT application. This was the international phase. It was just one application pending at the office in Geneva, but now you've got to split that application into all these different ones which go into all the different countries around the world. So then you enter the national phase in the US, in Japan, in Europe, in South Africa, and in any other countries of interest. And then you suddenly, from going from one PCT application, you now have an American application, you have a European application, you have a Japanese application. So you'd have to have your Japanese application translated into Japanese. You'd have to instruct a Japanese patent attorney. You'd have to make sure your application was in one of the European languages, and the European Patent Office will accept patent applications in English, French, and German. And so if it's not in one of those languages, you have to have it translated in English. Obviously, the US, they speak some form of English. It's not the same as ours, but you know, it is what it is. And then the US examiners will look at the US application and they will write to you separately, and they say it's either patentable or it's not. The Europeans will write to you separately and say it's either patentable or it's not. The Japanese will write to you. And then in South Africa, it's just like, you know, entering, it's like having a complete application in South Africa, and it'll go through to grant. So that's, I know, guys, your mind is exploding at the moment because this is a huge amount of information to take on board, but it's cool. When we have our next lecture and it's in venue, if you want me to go through this again, no problem, I will. Read Dean and Dyer. It does give you an explanation about it. Look at this, you know, what I'm sharing my screen with here, and you should see that it does all make sense. All right. So, and it's a little bit difficult to take on board today, but when you think about it and you go through it a couple of times, you'll see actually it's not hard. It's quite simple. And basically, what happens is, once you've filed your national phase application and you know, then countries like America, Japan, Europe, they will what's called substantively examine your application, and they will look at the subject matter, they will look at the claims, and they'll say, no, this is, you know, it's been anticipated by this prior document which is published before the priority date, so, you know, it's not novel, or it's obvious. It's just a minor difference over what's described in these previous documents. And this is when you as a patent attorney really come to the fore, because now you've got to start arguing inventive step and et cetera, et cetera. So that's really important. And that's, you know, where a lot of expense comes into it, because, you know, I'm charging $6,000 an hour to formulate arguments and to make changes to my claims. And then I send that letter to my US attorney. He's charging $700-800 an hour just to read through my letter, make sure he agrees with it, put it on his letterhead, send it to the USPTO, pay the fees to the USPTO. When the examiner there writes back to him, he's got to look at it, he's got to describe what's saying, send it back to me, I send it to client. It's just these charges, you know, just layer on layer on layer. Gets super, super expensive. So a lot of people sort of lose their appetite for filing these patent applications in these circumstances, but unfortunately that's how it goes. South Africa, on the other hand, does not examine substantively, and this is a very important point. Okay, South Africa will only make sure that you've paid the fees, that you've got your deed of assignment. There's a couple other sort of like legislative hoops you've got to go through in South Africa. You've got to make a declaration that you know, you've got the right to apply. You've got to make a declaration that all the inventors are there. That's quite an important declaration, because if you get that wrong, it can be grounds for revocation. And then you've got to declare in South Africa as well on what's called Form P26, Patent Form 26, that you're not using any indigenous local resource, biodiversity or anything like that. Because, you know, if you're using any of the plants in South Africa or animals in South Africa, and you're extracting, you know, chemicals from them or proteins from them or something like that, then a whole different legal system applies to that. And we will, in fact, go into that, the Biodiversity Act. That's for another lecture. But when you do your application in South Africa, you've got to declare that you're either using local indigenous resource or not. And if you are using local indigenous resource, there's a whole nother pathway that opens for you, that you have to prove that you've done certain things. But anyway, normally South Africa will just say, if you paid the fees, if you've got all the forms, yes, boom, it's granted. Thanks for playing. It's not like that in America. It's not like that in Europe. There you have to convince the examiner that the subject matter of your patent is in fact novel and inventive. And only when you've proved that to him and he accepts that is your patent granted. Okay, so now you've got a granted patent. What happens? It gets published, and now all of a sudden you have the right to exclude others from making, using, importing, keeping, disposing of your invention. All right, it's not a positive right, it's a negative right. You don't have the right to do it yourself because there might be local legislative requirements. Say, for example, if you've invented a pharmaceutical, you can't just start selling that pharmaceutical, right? You have to go through all the tests and you have to prove that it's safe and that it works and that people don't grow an arm out of their head when they take it. You know, you've got to go through all that Medicines Control Council stuff before, get your dossier together, go through all the regulation, and then you can do it. But what you can do is you can stop anybody else trying to do that as well, because you've got the right to stop them, but you don't have the right necessarily to market your product. Sometimes you do. If you're making a mousetrap, then you just go for it. But more often than not, you've got to get over all these regulatory approvals. But the point of a patent is that it is the right to stop others from using your invention. And that's what it is. Okay. And then, of course, you have the right, because that right you only get once your patent is granted. Up until now, while it's pending, etc., etc., that right to stop others is waiting in the wings. But you can't actually sue anybody for patent infringement unless and until it's been granted. And in fact, in South Africa, there is a moratorium, and that you can't actually sue anybody for patent infringement for 9 months after it has been granted. So what happens in South Africa, it gets accepted, and then within 3 months, you have to publish it in the Patent Journal. And from the date of publication in the Patent Journal, that's when it's granted. But you can't sue anybody for patent infringement that day. You've got to wait 9 months. And that's because South Africa is a non-examining country. And so you've got to give people the right to say, hey, man, this patent isn't worth the paper it's written on. Look what happened to the corresponding application in Europe. It got refused because it's not new. And so it gives other people the right to come into South Africa and attack it or have it revoked or whatever on the basis of the outcome of corresponding applications, to the extent that there are any in other jurisdictions. So the South African Act is filled with these little checks and balances, which most other acts don't have, because they're trying to level the playing field because we don't examine our patent applications. Okay, other countries don't have that, but we do because we don't examine. Other countries don't have that because they examine. So other things that countries do have, which South Africa doesn't have, is opposition. So, for example, in Europe, the patent is granted and advertised as having been granted in the European Patent Journal. That opens a 9-month window for somebody to say, hell no, we're not having that patent, and to oppose that patent, to pile in and say, you know what, this should never have been granted, and here's why. And those proceedings are actually heard before the Patent Office, before the people that granted the patent. And so it doesn't go to the courts or anything like that. It's an in-house Patent Office procedure, and it's a good procedure. But South Africa doesn't have that. Okay, if you want to revoke a granted patent in South Africa, you have to go to the High Court. Now, last year I was talking about last lecture I was talking about the Court of the Commissioner of Patents, and that's of course where it's heard in the first instance. But that is the High Court. So we need people like Sally and senior counsel. We need to instruct advocates to appear before a High Court judge to argue about why a patent is novel or not inventive and should never have been granted in the first place. So yeah, so that's how it kind of works in South Africa, is that we don't have opposition, we don't have examination, but we do have a 9-month moratorium. Now, one of the things that we will talk about in this case is what's called the South African White Paper, or the South African IP policy, where a lot of clever guys in government and the Patent Office, I know that sounds like an oxymoron, but you know, there are some very, very good people out there. They have realized that, yeah, you know what, this whole non-examination thing, it's a bit last century. I think we need to up our game a bit here in South Africa. So maybe we should start examining patent applications. Maybe we should start having an opposition procedure. And they've published this document, and it's been out there for a couple of years, but it is a policy document, the South African IP policy. I will share it with you. I will post it on Blackboard, and you guys can read it. And you can see how, although we don't have examination now, although we don't have opposition now, we're looking very seriously at introducing it. And this IP policy document looks at that and how it would actually work. In terms of examination, we've gone a step further. We've actually been training a cohort of examiners at the South African Patent Office. Now, they're not ready to be unleashed on the applicants just yet, okay? So they have been training up for the last couple of years, and what's happening to them is that they will now be issuing non-binding opinions. So when you get a patent application, you will get a letter from the Patent Office saying, this is not new, this is not novel, what are you going to do about it, kind of thing. Now, because it's not part of our law yet, we can say nothing. I'm not even going to bother to reply to that letter because it has no legal standing. It's just the newly trained examiners cutting their teeth. But because in practice, I want these guys to be good, right? I want there to be a rigorous examination process in South Africa. I want these examiners to succeed. What I'm going to do is I am going to reply to them, and I'm going to pretend that that letter does have legal force, and I'll give it my best arguments as to why that patent application should in fact be considered novel and inventive, and I'll make amendments and things like that. I'll treat it like the real deal because I want that examiner to get that kind of exposure so that when his letters do become of legal force and effect in the fullness of time, he will have a lot of experience and he will have, you know, kind of done all of this with me and other practitioners over the years. So he will have a lot of experience and he'll have got better. I want good arguments with our examiners, you know. I don't want it to be sort of meaningless. And so I'm going to do everything I can as a practitioner to make sure that those examiners know their stuff and that they're hard as nails, because that's what I want, because it's good for patent law in South Africa. So that's basically, you know, how patents are granted, how they proceed to grant not only in South Africa, but also how they proceed to grant in other countries. Now, just two final things. After they've been granted, the duration of a patent is 20 years, but it's 20 years from this date, the date on which the PCT application was filed. Or if you go up, it's 20 years from the date on which your South African or your US application was filed in terms of the Paris Convention. So it doesn't make any difference on which day your patent was granted, okay? It makes all the difference on which date you applied for your patent, i.e. the 12-month period following your priority date. And the 20-year monopoly is calculated from that date. You only get your 20-year monopoly if you pay annual renewal fees. They're often called maintenance fees as well. And they have to be paid every year on the anniversary of this date here, the 12-month, you know, the date of filing, either the PCT or the convention application. And you get your first 3 years free because, you know, often it hasn't been granted yet. You're still arguing with the examiner or whatever. So they'll give you your first 3 years free, but on the 3rd anniversary of filing your PCT application or your convention application, that's when your first renewal fee becomes payable. And they will be payable every year from then on until the 19th. And not only that, until the 20th year. Not only that, they get more expensive, okay? Now, renewal fees in South Africa are not a lot of money. It's a couple of $100 a year. But in Europe, like in Germany, your 20-year anniversary is something like 20,000 euros. It's an insane amount of money. So why is that? Okay. And it's because the patent offices are trying to incentivize people to drop their patents because they don't like patents which are not fulfilling any function from being held in place. So if you are in fact using your patent and it's generating a lot of money, 20,000 euros, well, not ideal, but you know, you'll pay that because you're making 10, 100, a million times that in terms of how much money you're making from your patent. So you're going to keep it in force. But if your patent, for whatever reason, never really got off the ground, you're not going to pay 20,000 euros in its last year. So you're going to let it become abandoned. You're going to let it become lapsed. And then it becomes public domain and everybody can do it. So you lose the right to enforce your patent against others. Okay. So that's pretty cool. And then you can, so you have to pay your renewal fees. If you forget to pay your renewal fee, then you have a 6-month grace period where you can pay it with a fine. and then your patent never lapses. But after 6 months, if you still haven't paid, it's lapsed, you can't get it back. Well, you can try, but it's a high court procedure, and you really have to go to town to say, look, I really didn't mean for this to lapse. It was a mistake. My computer crashed or whatever. You've got to demonstrate that it was never your intention to allow the application to lapse, and you really want it back, and you pay all the fees, etc., etc. Doesn't always work. The Europeans, they're not cool with that. If you miss your 6-month grace period, it's almost impossible to get it back, because they have very, very high standards of what they expect from you. I mean, if your office burned down, and you could say, well, I lost all my computers and everything, they're going to turn around and say, well, why didn't you have offsite backup? That it's not reasonable that you didn't have offsite backup. Sorry, you lost your computers. Application to restore refused. So they're really tough. Whereas in South Africa, they're like, morgen nog 'n dag, it'll be fine, no worries. So you have these different standards which apply around the world. Europe is tough. Europe is really, really tough. So you've got to understand that. So, okay, duration 20 years, provided you pay your annual renewal fee every year, calculated from the 3rd year to the end. It's not possible to extend a patent beyond its 20-year period. In Europe, it might be possible under certain circumstances to extend the protection for a very narrow aspect of the invention, if you can prove that it's in the interest to do so. So that is called a supplementary protection certificate, an SPC. We don't have them in South Africa, so it's not really important. But consider what happens with a blockbuster pharmaceutical invention. Okay, so you file your patent application in the year 2000. Okay, for a whole bunch of chemical compounds. They're all built off this one skeleton, but they've all got different things hanging off it. And one of those is the drug, and it is the drug. Okay, it's making you millions, but it took you 15 years to get regulatory approval for this drug. Okay, which is basically how long it takes. Okay, so not only did you have to do all your research to get to this class of drugs, then you had to select one that worked, and then you had to prove that it was safe and it worked, and you had to pay billions, in all these drug safety tests, etc., etc. So here you are, finally, in the year 2015, okay, where you get your dossier, your regulatory approval to say you can make and sell this drug, and this drug only, this particular compound. Okay, you have spent billions of dollars to get to that point. Okay, billions, not only in the initial R&D, your patent costs, which are not insubstantial, but are dwarfed by your R&D and regulation costs. Okay, but now you're ready to go. So you hit the market with your drug, and that, guys, is why drugs are so expensive. Okay, because they've got 5 years, the last 5 years of their 20-year monopoly, to make up all of those billions, right? And not only that, but to make a profit and to fund the next generation of drugs. Okay, so they've only got 5 years to make up all that money. That's why these drugs are hectically expensive for the most part. Okay, because they are recouping the costs and paying for the next generation. So some of the European countries have said, you know what, that 5-year period, it's a bit hectic to make back all of those billions. So what we'll do, we'll give you another 5 years, but only for that compound. So for all the other compounds, because your initial patent specification is broadly framed, it covers 1,000 compounds, they all become public domain. But this one blockbuster that you've got the regulatory for, that you've done all of this work for, that you prove works, that one you can have a supplementary protection certificate for that'll give you another 5 years. So say you had to make up 5 billion in costs and you only had 5 years, you'd have to price that drug that it yielded 1 billion a year in profits. But if you've got 10 years, you only have to yield 500 million every year. So you can see how it brings the price of the drug down, because you've doubled the period in which to make back that money. But of course, what they do is they don't They don't charge 1 billion a year. They charge, but they also don't charge 0.5 billion a year. They charge 0.75 billion a year. So everybody makes money, but the public is shielded to some degree from these expenses. So I know that sounds like outrageous, really, when you say it like that. You know, these drugs are so expensive, etc., etc. But as a patent attorney, you've really got to understand that that's unfortunately the reality, is that it costs billions to bring the next drug to market. And patents are the only way that protect these guys so that they get the billions that they spent back, and they have a fat bank account to fund the next round of R&D. We've got some brilliant drugs out there at the moment that save heart attacks, anti-cancer drugs, epilepsy, you name it. You know, all of these drugs are fantastic. But the drugs that are coming are going to be even better. And, you know, there will be many afflictions that you and my generation have that our kids won't have to worry about, because they'll have been solved. And they will have been solved because the patent system is there to incentivize and protect the solutions that come along. If you say to somebody, you've got to spend 5 billion to bring the next pharmaceutical solution to the market, but you won't get that money back, nobody's going to do it. They're going to say, it's not worth my while, you know. So unfortunately, it totally sucks, but it's the best system that we've got. If we've got another system to make it work, I want to hear all about it. But unfortunately, capitalism, incentivization, and profit, that's what brings solutions to the market. And that's basically how it works. So that's kind of a long way of explaining, you know, patent duration and the effect of a patent, you know, the right to exclude others, but not necessarily the right to practice yourself. So I hope that makes sense. Sally, you've got your hand up. Hopefully you've got a question for me.
Just to understand, so with the IP waiver with regards to COVID vaccines, you say that most pharmaceutical or most inventors, they have managed to capitalize on this, because now they don't have to wait for a long period.
Yeah, so that's why the waiver is just so contentious, Sally, because people are saying we need these drugs to you know, COVID is a pandemic, millions of people are dying, we need access to that drug now, we need the vaccine now. And now you're saying, oh no, you can only have it, I've got a patent on it, and you can only have it when you pay me $50. And yeah, that's, you know, there is a point to that argument, but you've also got to look at the fact that the South African Patent Act has a number of checks and balances in it, which in times of emergency, in times of dire need, allows the government to walk in and expropriate patents as needed. So, you know, I've always said from the very beginning, a patent is like a piece of property, like a house or a car or whatever. And if you've got like a big piece of property, but the government or the city council decides they want to build a road through there, they will just come and expropriate a piece of your property, right? And say, sorry, but we need this to build a road. And maybe they'll pay you and maybe they won't. It's exactly the same with patents. The government already has walk-in rights for patents in South Africa. And so there's no need to have a broad blanket waiver. It's very political. All you have to do is look at the existing Patents Act, and you can see the government has every tool that they need in these kind of instances, because, you know, COVID is not the first time we've had this problem. Think about HIV, think about tuberculosis, you know, and you know, but when you start saying, I'm just expropriating these patents, wow, you know, you're really opening up a hornet's nest, because people are saying, well, why should I even bother bringing the next generation solutions if you're just going to expropriate it and give it away for free? Yeah, I understand people are dying and all the rest of it, but, you know, I spent 5 billion to bring you this solution, and you've just said thanks very much and taken it. You haven't allowed me to make back that 5 billion. So, you know, it's going to play havoc with the incentivization. It also doesn't solve it from a number of other reasons. You know, you need the regulatory data. You need to be able to make like, for example, if you consider an mRNA vaccine, which is what this is all about for COVID, they're extremely complex to make. You need massive factories, you need good manufacturing process, you need a lot of technical know-how, which not all of which is included in the patents. You need to have that experience as an experienced manufacturer. You've got to know how to build a factory. You've got to build a factory, to make these things. So patent waiver is really, it's not the answer, is the bottom line. Now, what I'm going to do is I'm going to post on Blackboard an excellent paper on patent waivers, how they work, and why they don't actually solve the problem. And I encourage you to read it, Sally, because it'll answer all of these questions that you've raised. Okay, your hand is still up. Are we good?
Is it down?
Now it's down, yeah. Now it's down. Great. Okay, guys, we've been going an hour and a half. So all that's left is amendment and correction, and then sort of and some sort of opposition. So can I suggest we just take a 5-minute break, and we'll leave it recording. I'll just switch my camera off, switch my microphone off, and we'll come back. So it's 10:35 now, exactly 5 minutes, 10:40. I'll start again. If that's okay, we can just take a quick break. All right. Thanks, guys. Hey guys, welcome back. I'm assuming everybody's there, so that's great. All right. I absolutely totally want to wind this up by 11:30. So, there's really not a lot to go. So hopefully we can do that. Okay, so what are we going to talk about now? We're going to talk about corrections and amendments and the difference between corrections and amendments. Okay, so let's I just want to go back to the fundamental philosophy of patents, right? Which is you provide a solution and which, solves a problem that afflicts society. And in return, you have the right to prevent others from practicing the invention, which is the solution to the problem, right? So what you're doing is you're holding a monopoly over the public. And so that's why it's so important that patents are published, because people must know what they're not allowed to do. That's really important, okay? This is not Russia, where they just make it up as they go along. Here, it's objective. And this, in as many words, is what you're not allowed to do. So if you want to come along now and start changing that by way of correction or amendment, this is something that is taken very seriously, because you are changing the ambit of the monopoly. You are changing the rules, what people can and cannot do. So say, for example, you can say the invention is that you use 10 mils of, bleach. So everybody says you can't use 10 mils of bleach, okay? But you can use 20 mils, okay? Because the invention ends at 10. But then you come along later and you say, sorry, there was a clerical error. I didn't mean 10, I actually meant 20. So then you just, and they say, cool, should we change it to 20? That's fine. You have, as a guy, have been reading this patent and it said 10. You said, okay, 20 isn't 10. I'm happy to use 20. I can escape the patent by doing that. You use 20. Boom, they come and change the patent. And now all of a sudden you're infringing. So you can't do that, right? You can't do that. So there are lots of rules and regulations about amending patents, because basically you are moving the goalposts when you amend patents, right? So the first thing they do is they say, well, when we look at a mistake, there are two kinds of mistake. There is a substantive mistake and there is an unintentional error, okay? And so errors per se are corrected and fundamental mistakes are amended. So there's correction and there is amendment, okay? So correction is dealt with under section 50 of the Act. An amendment is dealt with under section 51 of the Act, okay? So they immediately recognize that there are two different kinds of mistakes, a correction and an amendment. So what's the difference? Okay, so the first one is, what's a correction, okay? There have been 3 cases which dealt with what is a clerical error, and I will expect you to know all of these 3 cases, and they're all set out. They are Macaulay Corporation versus Brickell, Hokuriku Pharmaceutical versus Cipla MedPro, and Pfizer Limited versus Cipla. And basically, and they all talk about, what's a clerical error? And it'll be things like a careless error, unintentional, inadvertently made, unintentionally transferred. Okay, so it would be things like mechanical errors, and this is a patent attorney's nightmare. Okay, so this has happened to me once before. I was dealing with an invention that utilized what's called gamma radiation. So gamma radiation is a type of radiation. You get X-rays and this and then the next thing, and gamma is particular wavelength, all right? So when you're talking about it, I was describing gamma. So in Word, the gamma symbol is a little symbol that you can get from pulling it down on a little submenu, and you can click on the gamma sign and say put it in the spec. Okay, and I was like, cool, I'm going to do that. But luckily, the first time I did that, I put the little gamma sign in the spec, and then I opened brackets and I said gamma, G-A-M-M-Y, gamma. close brackets, and then moved on. And then for the rest of the spec, whenever I wanted to use, I meant gamma, I just cut and paste that little symbol in. Okay. Well, when it came to printing the specification for submission to the Patent Office, that little gamma signal wasn't interpreted correctly by the computer. And all I got, instead of the gamma Greek symbol, I got a little square black dot. That was what the computer did. It was unintentional. It was mechanical. It was a mistake. Okay. But luckily, the first time I had used it, I had said afterwards, that means gamma, G-A-M-M-Y. So I was able to say, listen, I need to correct all of those little black dots to the gamma symbol. And you can see that it was unintentional because it's a mechanical error in translation, going from Word to PDF or whatever. And you can see that it's clear what I always meant it to be, because there's a little black dot and then I say gamma. So whenever there's a little black dot, it should be a gamma symbol because I said it in the beginning. And they were like, absolutely. It was an unintentional fault. It was clear what it should have been, and it was mechanical in nature because it was a translation problem moving from Word to PDF. So that saved my bacon that day. Okay, so that is a clerical error. So when you read those three cases, they go into, you know, like what they'll consider a clerical error. Fine, section 50, easy peasy. All you do to correct a clerical error is you put together a form P4. You say, this is a mistake. This is how I plan to correct it. Here's my clean page showing the correction. And the registrar says, sweet. It costs a little bit of money, 50 bucks or whatever. Stamp, stamp, stamp. Everybody's fine. Okay. Now we move on to section 51, amendments. Completely different kettle of fish. Okay. Bearing in mind the South African patents are not amended, so nobody's going to pick these up, right? It's up to you to sort it out. Okay. And there are, now you're talking about making changes which are pretty fundamental, which are there because you want to change the scope of the claim. You want to maybe introduce new claims which you hadn't introduced before. You know, you need to change ranges within the claim, and because of prior art, you need to narrow your claim to avoid some prior art. Or because you see somebody out there and he's doing something, then you want to stop him, so you're going to try and broaden the ambit of the claim. And so how it works with amendments is that amendments themselves are divided into basically two categories. Amending a patent application, which is to say a patent specification which has not yet been granted, and amending a patent post-grant. Okay, once it's been granted, once it's been published, and the two are very different. Okay, so, and there are different things as to what you can do. So an overriding criteria for when amending a patent is that you cannot amend a patent to include anything that wasn't originally in the patent description as a whole, which is that whole document I was talking about at the beginning of this lecture, which includes the examples, the different embodiments, the whole nine things. So that's why when you draft your patent application text, you have to be as thorough as possible. You've really got to explore the ranges. You've got to think about, he said spring. Does he mean a leaf spring or a coil spring or a piece of rubber that is just biased in one way? You know, you've really got to think of all these different embodiments because you might want to have reference to them later on when you amend it. So if you just say the spring is a coil spring, and then later on, you want to amend your application to include a leaf spring. If you haven't said leaf spring originally, you're done. You can't introduce new matter, okay? The introduction of new matter is something which is very critically looked at by judges. And you're not going to get away with including anything that wasn't originally included in your specification, one way or other, be it in the claims, be it in the description, be it in the examples, okay, be it in the embodiments. If it's not there, you're not going to get it in, okay? So it's really important that you understand that. That works across the board, okay? When you are when you are amending a pending application, there are two things you can do. You can broaden the scope of the claim, which is to say that you can, you know, if it said between 1 and 10, but your description made allowances for it to go to 15, you can actually say 1 to 15 based on example number, whatever. And you can do that because it's not granted yet. So you can include a scope of claim, you can broaden the scope of claim to something that was broader than it was before. And you can also introduce new independent claims. So you can say, you know, say you've got a mousetrap, and your first claim is to a mousetrap, including a spring and a this and a that, and that was just your only claim, just to a mousetrap. Now you can come in and you can say, a method of catching a mouse, the method including the step of using a mousetrap and putting out a piece of cheese. And so now you have a different kind of claim. The first kind of claim just claimed a mousetrap, but the second kind of claim claimed a method of using the mousetrap. And so you can do that when the application is still pending. You cannot do either of those things once the application is granted, okay? Once the application is granted, you can't include a new type of claim, so no new independent claims, and you can't expand a claim. So if you said 1 to 10, you can only take it down from then to 9, 8, 7, 6, 5. You can't take it to 11, 12, 13, 14, 15 after it's been granted. You can do that before, but once it's been granted and the ambit of monopoly has been established and published, that's it. It can only be narrow. It can't be broadened after grant. Okay. When you make application to amend either a pending application or a granted application, you have to be 100% honest about what you're doing and why you're doing it. It's taken very seriously. You are interfering with a monopoly that's holding the population of South Africa, 60 million people, to its, you know, its lawful metes and bounds. You need to be 100% about what you're doing. So you need to, how it works in practice is basically you need to set out your full reasons for making the amendment. So you can say I'm limiting the claim because I found a piece of prior art which anticipates a portion of my claim, so I'm limiting my claim to avoid that piece of prior art. You can say I'm changing the format of the claim to accord with the requirements of South African law. You recall in the last lecture I said you can't have a method of treatment of a human or animal body, but you can have a compound for use in a method of treatment. So you can change method of treatment claims to compounds for use, provided it's not a granted patent, right? Because that's changing the type of claim. So you can't include new independent claims, that kind of thing. So, and then you've got to say, I'm doing this because of this. And then you have to say, here's the page that as originally filed, and here's what I'm doing. And I'm underlining it in red. I'm deleting this word and I'm including this word. That's called a marked up copy. Word is brilliant at doing this for you. So you can delete it, it'll mark it in red and it'll strike it through. And then the word that you want to put in, you type in and it'll underline it and put it in red. So it's immediately clear what changes have been made. So you need to submit a markup copy of the pages as originally filed. And then you also have to put in a clean copy of the pages that were filed initially. Markups, cleans, full reasons, and a certificate to say, this is what I'm amending, and this is the exact copy of what's on file. So you have to be really, really careful. Now, if you do all of that, and it's quite expensive, it's a couple of £100 to, relatively speaking, to make an amendment to a pending application. So if you do all of that, you've got your Form P12, which sets out your full reasons. You've got your certificate saying that these are the original pages that are being amended. You've got your reds or your markups, and you've got your cleans. Then the registrar will say, you know, it's a pending application. This guy's given me full reasons. He's paid his money. Stamp. You're good. If it's granted, there's another hoop you have to jump through. If it's granted, you've got to do all of that. It's a Form P13, not a P12, but you've got to do your reds, your cleans, Form P13, full reasons, certificate. And then it gets published because now it's a granted patent. Now you're interfering with a monopoly that binds 60 million South Africans. This is serious. So what happens is you put your application in to amend, and the registrar says, okay, you've paid your money, da 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 da. Now I'm going to advertise the fact that you want to amend this application. And what he does is he publishes it in the patent journal and he says, John McKnight wants to amend South African patent number, whatever. If you want to come and have a look, the amendments are open for public inspection. And there is a 2-month window in which anybody can say, hell no, we're not having that. And they can oppose those amendments, okay? They can pile in and they can put paperwork into the patent office and say, you know what? He can't amend because he's not complying, he's adding new matter, he's putting in a new independent claim, and that's not allowed, etc., etc. All those reasons that I said you've got to comply with. If you don't comply with any of them, anybody, any interested party can pile in and say, hell no, we're not having that. So that is opposition, right? That's the only opposition that we have in South Africa, and that is when you're trying to amend a granted patent. Then the registrar will advertise, and you have a 2-month window for third parties to oppose your proposed amendments. If you hear nothing after 2 months, then they just accept it. If there is an opposition proceeding, it's heard by the registrar, but it almost always gets flicked up to the commissioner in the Court of Patents. So you can see it's a drama. And so you want to get it right. When you're amending a patent, you take it super seriously and you want to get it right. Amending patent applications has to be signed off by a patent attorney because it's so important. You can't have clerks do it. You can't have attorneys who are not registered patent attorneys amend patent applications or granted patents. The last thing I want to talk about is there is a third way of amending patents, and that is when a patent is the subject of litigation, be it infringement or revocation or whatever. And so the parties are having a big fight, and the patentee, the proprietor of the patent says, oh, these guys have got a point. You know, that is a piece of prior art that I hadn't seen. It does anticipate a portion of my claim. I need right now. That means even if a tiny part of your claim is anticipated, the whole claim is dead. Even though, you know, if you haven't amended it to avoid that piece of prior art, if you just keep it there, it's dead in the water. It's not enforceable. You can't assert it against anybody. They can't infringe an invalid claim. So you need to carve out the bad bit of the claim. You need to amend your patent. And you can do this in the middle of litigation. When you see what the other side, the arguments of the other side, you can say, oh, they've got a point, I need to sort this out. So pending litigation, in litigo, you can actually amend your application. And then, of course, then it becomes the subject of the litigation, because the infringement or the revocation then gets put on hold while you talk about the proposed amendment. Because if the proposed amendment is allowable, it might save the patent from revocation, but it also might, or you might fall outside of the new ambit in an infringement proceeding. So it's important you settle the ambit of the claim before you can really talk meaningfully about infringement or revocation. So it stays proceedings, and then the parties start fighting about whether this amendment is allowable or not. So that is amendment in the middle of litigation, and that's all set out in, so it's amendment of a patent in the course of legal proceedings, and it's section 51(9) of the Act. So I'd encourage you to have a look at that. And then there's talks about, okay, so, you know, what are the grounds of an objection to amendments? It's pretty easy. Failure to comply with any of these requirements, which I set out above. Following the incorrect procedure. Interesting one, third one, continuing invalidity after amendment. Okay, so you can say, you know, even if you allowed that amendment, it would still be, you know, it's still not valid. Then the amendment is pointless, so I'm not even going to allow it. Okay, and then a third one, which is really interesting, is there's case law, which says that as a proprietor, it's the Lundbeck case. As a proprietor, so say you've got applications pending in the US, Europe, and South Africa. Now, South Africa, if you don't do anything, you don't make any amendments, it's just going to go through to grant, right? It's not substantively examined. The registrar is just like, cool, you paid your fees, stamp, thanks for playing. But in Europe and America, you've got all of these examiners and experts looking at it. And you might be forced to narrow the scope of your claim before they will allow you to, before they will accept your application, before it's allowed to go to grant. So what needs to happen is you need to import those amendments that were made to the European and or the American into South Africa, because you know, as the applicant, you've taken a couple of body blows in Europe on the corresponding application. You know that your broad ambit that you got in South Africa isn't valid. And if you knew that and you delayed amending your application in South Africa down to a narrower claim ambit, which you know is valid because of what happened in Europe, if you delayed that and the court thinks that it's undue delay or prejudicial, they won't allow you to subsequently amend. So that's quite interesting. Undue delay or prejudicial conduct on the part of the applicant for an amendment. This can be a bar to the allowance of the application. The courts have said the following: the legal position on the question of delay on the part of a patentee in applying for amendments has been considered in a number of cases. A deliberate intention to delay, knowing full well that some of the claims are invalid, can in some circumstances be a bar to allowing the amendment. Even though a patentee never intended to enforce the invalid claims, he nonetheless created an area which prevented competitors from freely entering it when he knew he shouldn't have. So that's mala fide conduct on the part of the patent proprietor, and as such, he's not going to be allowed to amend his patent. So that's quite interesting. So you should have a look at that, and you should also have a look at the water renovation patent, which deals with when the amendment is a mere stratagem, which is to say it's dilatory, or it's working to another agenda. So that's it. So amendments are taken very, very seriously, and you know, it's a good idea. You need to know the different kinds of corrections and amendment. You need to know the different rules that apply to amending a patent before it's granted, after it's granted, and during litigation, and what you can and cannot do. So those are quite important aspects. Dean and Dyer cover it very well. The case law is super important on this kind of analysis. And that, I'm very pleased to say, brings us to the end of today's lecture. So I'm obviously going to record this, post it up onto Blackboard. I'm going to put this Word document up onto Blackboard. I'm going to put the IP policy up onto Blackboard, and there'll be a few more other things there as well. So have a look at that. Let me know if there's any questions, and then I will be in touch regarding the lecture on the 2nd of April. And I will also be in touch about the assignment, which is coming. I will give you 6 weeks to complete the assignment. So that means I'll have to, if I need to get it in the middle of May, I need to give you that assignment quite quickly. So that will be the subject of a separate email, which I'll send out shortly. You are encouraged to reach out and contact me if there's anything you don't understand. I've got an open door policy, very happy to hear you, failing which I'll be in touch. And I think that's everything from today. So unless there's any questions, I think we're good to go.
Prof.
Yeah, Taviso.
2 questions. Can I go ahead?
Yeah, please go ahead. Yeah.
In terms of section 50.
Yeah.
The first question I have there, are intellectual errors allowable? Can you correct intellectual errors? Because I see in that Macaulay case, they said a clerical error is only classified as what is this? A mechanical error.
Yeah, inadvertently made.
Mm-hmm.
So when you talk about an intellectual error, you're talking about something which was a misunderstanding, where when you wrote it down, you thought it was correct, but upon further research or further work, you realize that it was actually incorrect. And that comes upon you only as a result of more work and more thinking about it later. That is clearly an amendment under Section 51.
Okay. Okay, thank you, Prof. Then in terms of Section 51,
yeah,
can any member of the public ask the registrar for an amendment of an existing patent?
No, only the proprietor. Only the proprietor can amend his own patent.
Okay. Thank you, Prof.
Cool. Good questions. Thanks to Piso. Okay, guys. Sally, unless there's anything, I'm going to say goodbye, and I'll be in touch over the next few days, and I look forward to chatting to you then. Are you good?
Yeah, I'm fine. Thank you, Prof.
Great stuff. All right. Thanks for your attention, guys. Good one. We did some good work today, and we'll be in touch.
Thank you.
All right, then. I'm going to stop recording. Thanks, guys. Bye now.
Bye.
Bye.